Hi! Hello! Kumusta naman? Natanggap niyo na ba ang mga term exam result niyo? Pa-comment naman if somehow nakatulong yung lecture series natin, okay? Ano ba yung term exam score niyo? If you want to share, comment down below. Pero kung hindi, okay lang din. Okay rin naman to keep your privacy, okay? Feeling ko naman magaganda yung result niyo kasi the fact na nanonood kayo ng lectures instead of kung ano-ano man yan dito sa YouTube, meaning mga good students kayo, di ba? Yay! So now, we will be discussing the second mode of extinguishment of obligation. The most normal mode talaga to extinguish an obligation is payment. Pero sa batas, marami pang ibang paraan in order to extinguish an obligation. Isa na nga rito is yung topic natin ngayon, loss of the thing due. That is Article 1262 to 1269. So, simulan na natin. Bago natin i-discuss ang Article 1262, klaruhin lang natin para naman on the same page tayo, okay? Loss under this section includes impossibility of performance. Hindi lang siya yung ordinary loss or wala na wala. It also includes in an obligation to do or yung sa mga personal obligations, okay? Loss also includes impossibility of performance, okay? So, when you say there is loss, na-discuss na natin siya before. But then, okay, to remind you, there is loss when accordingly the object perishes, or it goes out of commerce, or if it disappears in such a way that its existence is unknown or it cannot be recovered, diba? Tapos, there is impossibility of performance naman if pag merong physical impossibility, legal impossibility, ganon. Okay? Anyway, madi-discuss natin siya later as we go on with our lectures. So now, let's discuss kung ano ba ang epekto ng loss under Article 1262. So we have to determine if it involves specific or generic thing. So Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor, and before he has incurred in delay. When by law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires the assumption of risk. So, ito yung first scenario. If it involves a specific or determinate thing, the obligation is extinguished. Okay? Pag nawala yung specific na bagay, the obligation is extinguished. But note ha, it should be without the fault of the debtor. And bago pa man nagkaroon daw ng delay. Yun yung sabi ni Article 1262. Pero sabi rin naman mismo ni Article 1262, nag-provide din siya ng exceptions. Diba? Pag daw yung specific thing nawala, the obligation is not extinguished. Pag eto, nasa second paragraph actually ni 1262, first, pag sinabi ng batas, when the law provides. Tapos, or stipulation. So, meaning, pag nasa kontrata mismo ng parties. Tapos, third, when the nature of the obligation requires the assumption of risk. Ito naman yung nasa last sentence ng second paragraph. Na-discuss na rin natin to previously. Kung naaalala nyo, supposedly maaalala nyo kasi kaka-term exam nyo lang. So, hindi siya foreign or alien sa inyo. Anyway, ano ba yung examples or instances when the law requires liability even in case of a fortuitous event? Kahit na may fortuitous event, magiging liable ka pa rin dahil yun yung sabi ng batas. First, pag daw si debtor is in default, 'di ba? under Article 1165. Na-discuss na natin ito before. Tapos another scenario is when the debtor has promised to deliver the same thing to two or more persons who do not have the same interest. Article 1165 pa rin yan. Tapos, a third scenario or example, when the obligation arises from a crime. Ito, madidiscuss natin later on sa Article 1268. So, yun yung mga instances kung saan the law provides or requires liability kahit pa due to a fortuitous event. Tandaan nyo yan, okay, class? Tandaan nyo, magiging magaling kayo sa mga problems later on. Anyway, so pagpasok dito sa tatlong situations na sinabi ko, kahit pa nawala yung specific thing, magiging liable pa rin si debtor. Yung sa assumption of risk, baka nakalimutan nyo ha, yung pinaka-example doon is yung sa insurance. Kasi yun naman on the first place, yung purpose niya. Inassume niya yung risk. Diba? Anyway, proceed tayo. Sa second scenario, pag generic or indeterminate thing naman, if it involves, yung obligation involves generic or indeterminate thing. Ito, actually, ay nasa kasunod na provision sa pwede tayong mag-proceed na sa Article 1263. Alam nyo, class, this is more on confirming na lang dun sa natutunan nyo previously. So, medyo madali lang talaga to. But then, mas maganda pa rin naman ma-master nyo para walang kawala ang exams, di ba? Perfect dapat. Anyway, so, proceed na nga tayo. Article 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So, malamang, alam nyo na to at masters nyo na to. Na pag yung generic thing nawala, magiging liable pa rin kasi hindi siya nag-i-extinguish ng obligation under the principle, genus never perishes. Okay? But note also, meron din naman itong exceptions. Have you heard about the concept of delimited generic? Ganito siya. Example, ha? If Pogi obliged himself to deliver to Ganda 100 sacks of rice from his December 2020 harvest. So, yung 100 sacks of rice from Pogi's December 2020 harvest is a delimited generic thing. Ang epekto nito is kung nagkaroon ng typhoon which completely destroyed the supposedly harvest ni Pogi sa December 2020, the obligation is totally extinguished. Okay? Nagets nyo? Kasi if yung example is ganito lang, Pogi obliged himself to deliver to Ganda 100 sacks of rice. So, ganyan lang. Tapos nagkaroon ng typhoon. Kaya nawala yung So, kaya nagkaroon ng loss. So, ang tanong, would Pogi be still liable? Of course, Pogi will still be liable dahil applying Article 1263 in an obligation to deliver a generic thing, the loss or destruction of anything of the same kind does not extinguish the obligation. So, generic naman di ba? Pwede pa siyang kumuha sa ibang source ng 100 sacks of rice. Unlike dun sa previous example natin, di ba? Delimited generic yun. Nilagay kasi doon na dapat yung rice na, kumbaga yung obligation niya to deliver 100 sacks of rice is from his December 2020 harvest lang. Okay? Gets nyo? Okay? Basta, klaro na rin naman ata. Uy, baka naman pala, ang layo na ng discussion natin. Di nyo pa alam or naguguluhan pa kayo pag sinasabi kong obligation is extinguished. Meaning, the obligation to deliver or to perform is wala na, di ba? Dito sa loss as a ground for or is a mode for extinguishment of obligation, itong sa loss of the thing, mai-extinguish siya dahil obviously it is no longer possible to deliver such thing kasi nga nawala or naging impossible nang gawin, di ba? And since nga nawala na rin naman yung specific thing na ibibigay sana, so ang mangyayari na lang is mako-convert yung obligation into a monetary obligation. Okay? Now, Article 1264. The courts shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. So this provision talks about the effect of partial loss of a specific thing. It answers the question, when is partial loss considered as a total loss? May mga instances kasi na yung partial loss, although partial lang, hindi naman lahat nawala, hindi naman completely nawala, pero yung loss is so significant na pwede nang ma-considered as total loss. So example yung loss ng body of the ballpen. Yung natira is yung cover ng ballpen na lang. 'Di ba? Although partial loss, pero ano pang silbi ng cover? So, when the loss is so material and the remaining portion of the object is insignificant or immaterial, partial loss of the thing may be considered as total. Pero take note sa sinabi ni Article 1264. The courts shall determine whether, under the circumstances, the partial loss of the object of the obligation is so important as to extinguish the obligation. So it is the court who is given the discretion in case of disagreement between the parties to determine whether the partial loss is such as to be equivalent to a complete or total loss. Okay? Article 1265. Whenever the thing is lost in the possession of the debtor, it shall be presumed that the loss was due to his fault, unless there is proof to the contrary. And without prejudice to the provisions of Article 1165, this presumption does not apply in case of earthquake, flood, storm, or other natural calamity. Okay, meron na naman tayong cases ng presumptions under the law. So Article 1265, ang sabi niya, there is a presumption that loss was due to the debtor's fault if the thing is lost in his possession. Pag yung bagay ay nawala habang nasa kay debtor, okay? Habang nasa kanyang mga kamay or nasa kanyang possession, the debtor is presumed to be at fault. Wait baka ma-confused kayo. Ang sabi, presumption lang. Hindi sinabing at fault na talaga. Presumption lang, meaning pwede mo pa rin namang ma-overcome ang presumption. How? By providing proofs na hindi ka naman talaga at fault kung ikaw si debtor. Okay? So, parang meron lang tayong legal presumption. It gives a debtor another duty to prove na hindi naman siya at fault. So, if nawala ang bagay sa kanyang mga kamay or nasa kanyang pangangalaga, there is a presumption that the loss was due to his fault. Now, is this presumption absolute? Hindi. Okay? Dahil mismo nasa rule or sa article na rin naman din na to, it also provides for a situation kung kailan hindi rin applicable yung presumption. Walang presumption na may kasalanan si debtor. Kailan? Sabi, the presumption of fault ni debtor is not applicable in case of natural calamity. Sabi nga pag binasa mo yung last sentence, di ba? This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. So, example tayo. Pogi borrowed a car from Ganda. At habang nasa kay Pogi ang sasakyan, ito ay nawala. So, dito may presumption na nawala ang car ni Ganda at default of Pogi. Hindi niya pwedeng basta na lang sabihin na, Ganda, nawala ko ang car na hiniram ko sa'yo without my fault. And so, dahil without my fault, nawala, na-extinguish na rin yung obligation ko. Okay? Pag ganyan lang, that is not enough to extinguish Pogi's obligation. He is presumed at fault. So, he is liable unless ma-prove niya na or mag-present siya ng mga proofs to show na it is actually lost through without his fault. Okay? Suppose, ganito ang nangyari. Nagkaroon pala ng sunog sa bahay ni Pogi. And let's assume na yung sunog was accidental in origin. So, dahil nandun sa bahay ni Pogi yung sasakyan na hiniram niya kay Ganda, kasama sa nasunog yung car. Okay. Pag ganito, hindi applicable yung presumption. Yung last sentence ni Article 1265, yung applicable, sabi, di ba? This presumption does not apply in case of earthquake, flood, storm, or other natural calamity. So, walang presumption na at fault si debtor or si Pogi. Since dahil walang presumption, pwede pa rin i-prove naman ni Ganda na Pogi was at fault kung kaya nawala ang kanyang sasakyan para maging liable si Pogi. Pero hindi pinipresumed na at fault si Pogi. Okay? That's it. So, Article 1266. The debtor in obligations to do shall also be released when the prestation becomes legally or physically impossible without the fault of the obligor. So, this is about the loss in personal obligations. As I said previously, loss is not just limited sa loss of a thing. Kasama din dito yung impossibility of performance. So, Article 1266 talks about the effects of loss or impossibility of performance in personal obligations. Sabi nga, the debtor in obligations to do, so meaning, in personal obligations, shall also be released. Okay? Released from liability, yung ibig sabihin yan. So, when the prestation becomes legally or physically impossible. So, we have legal impossibility and physical impossibility. And yung last phrase na napakahalaga, without the fault of the obligor. So, obviously, dapat walang fault si debtor para ma-extinguish yung obligation. So, ito na yung ito pala yung dapat. Impossibility must exist after the constitution of obligation. Kasi, if before, then there is really no obligation to speak of on the first place, di ba? Walang obligation na ma-extinguish on the first place kung impossible na siya bago pa man nagkaroon ng obligation. So, meaning, nagkaroon muna ng obligation. Yan yung situation sa provision na to, kasi extinguishment nga eh. So, actually, pag binasa mo rin naman yung Article 1267, 66, makikita mo talaga dito na sinabi niya, prestation becomes legally or physically impossible. Diba? May words na becomes. Word na becomes. So, nauna talagang nagkaroon pa ng obligation, tapos later on, it becomes impossible. Dahil naging imposible na, and without default of the debtor, the obligation is extinguished. Wala ng liability. Okay? So, ano ba ang example ng legal impossibility and physical impossibility? Eto. Pogi obliged himself to construct a commercial building for Ganda. Tapos 1 week after, namatay si Pogi. Obviously, as a result, he can no longer build or construct the commercial building for Ganda, di ba? Hence, the obligation of Pogi has become physically impossible. Papaano pa namatay na siya? So, therefore, Pogi was released from his obligation. Another example, hindi naman namatay or na-aksidente or what si Pogi. It's just that the government refuses to issue building permit kasi daw the area has already been declared by law as a residential zone. So in this case, yung obligation ni Pogi was also extinguished kasi it has become legally impossible. Kasi di ba kailangan mo naman ng business permit, building permit para mag-construct ka ng building eh. Hindi na pwede kasi nga hindi na siya commercial area na declared na siya as residential area. So, legally impossible. So, that's it. Article 1267 na tayo. When the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom in whole or in part. So, Article 1267 is another exception to the obligatory force of a valid and enforceable contract. Diba? Kasi, when the performance of service has become so difficult daw as to be manifestly beyond the contemplation of the both parties to so the court is authorized to release the obligor in whole or in part. Example is yung the duty to construct a road, tapos biglang nagkaroon ng earthquake. So, ang lakas ng earthquake so as to change the condition of the land to the point talaga na such construction was possible but very dangerous to life and property. And so, it is something that is not contemplated by both parties na mangyayari. Diba? So, sabi ni Article 1267, the debtor can be released from his obligation. Pero take note one party must ask for relief. Okay? So, that's it. Article 1268 na tayo. When the debtor of a thing, certain and determinate, proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss, unless the thing having been offered by him to the person who should have received it, the latter refused without justification to accept it. So, ito yung epekto ng loss in criminal offenses. Ang sabi, when the debt of a thing certain and determinate proceeds from a criminal offense, the debtor shall not be exempted from the payment of its price, whatever may be the cause for the loss. So, pag daw yung isang bagay is a proceeds from a criminal offense, hindi mai-exempt si debtor from his liability, whatever may be the cause for the loss, either with or even without his fault. Pag yung nawalang bagay is a proceeds from a criminal offense, si debtor is liable. May fault man siya or wala. This is actually another instance kung saan kahit pa due to a fortuitous event yung pagkawala ng isang bagay, magiging liable pa rin. Okay? Now, please note also yung exception. Unless the thing having been offered by him to the person who should receive it, the latter refused without justification to accept it. So meaning, if si creditor is in default, pag may mora accipiende. Default in the part of the creditor. So example, ganito. Si Pogi, ninakaw niya yung sasakyan ni Ganda, and so ngayon, he is now ordered to return the stolen car sa may-ari, kay Ganda. Pero, bago pa na-deliver ni Pogi ang sasakyan, nagkaroon ng sunog sa bahay ni Pogi, at nasunog pati ang sasakyan ni Ganda. Question: is Pogi's obligation extinguished? No, Pogi's liability is not extinguished. Bakit? Kasi nga, yung obligation to deliver the car arose from a criminal offense. And in such a case, the rule is he is liable even if he lost or the loss occurs because of a fortuitous event. Kahit pa meron or walang fault si Pogi, siya ay magiging liable. Napakalinaw niyan sa kay Article 1268. Now, supposed, on the date of delivery, bago pa man nasunog, si Pogi, he has already tendered the car to Ganda, but Ganda refused to accept without just cost. So, subsequently, nasunog na nga ang sasakyan. Is the obligation to deliver extinguished? So, dito, hindi na kasi si Ganda is in mora accipiende. Okay? Ito yung exception to the rule na sinasabi kanina na pag si creditor is in default. So, my follow-up question. If Ganda refused to accept the car, what should Pogi do? Ano ba yung dapat niyang gawin kasi ni-refuse to accept? Ano yung answer? Na-discuss natin previously in yung last video natin. So, si Pogi has an option either to consign the thing to the court or keep it in his possession hanggang sa ma-deliver niya kay Ganda. Okay, so pwede yung consignation or kung ayaw niya naman, pwede niya rin namang i-keep na lang in his possession yung car. Pero, in that case, he has to exercise due diligence of a good father of a family. Anyway, proceed na tayo kay Article 1269, the last article for this video. So, the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against third person by reason of the loss. So, eto yung right of the creditor to proceed against third person. Sa article na to, si creditor is given the right to proceed against third person responsible for the loss, okay? There is no need for an assignment kay the debtor. So, yung right ni creditor, yung right ni debtor against third person is transferred or maa-acquire ni creditor by operation of law by virtue of Article 1269 in order to protect the interest of the creditor. Eto, example. Example na tayo. Para matapos na rin. Pogi is obliged himself to deliver to Ganda a specific watch, okay? Pero itong si Beauty, kinuha niya yung watch and then dahil dito, nung kinuha niya, nawala niya at her fault, okay? Fault ni Beauty. Ang sabi ni Article 1268, si Ganda has a right to sue Beauty, okay? Bakit? The rationale for this is this kasi nung nawala daw yung watch through the fault of Beauty, yung obligation ni Pogi, the obligation of Pogi to deliver that watch to Ganda was actually extinguished. Hindi na siya liable, di ba? Hence, he would actually no longer be interested to go after or to go against Beauty. And so, to protect the right of Ganda as a creditor, binigyan siya ng batas, binigyan siya ng right to proceed against the third person, which is, in this example, si Beauty. Okay? That's it. Thank you. Salamat for watching. And so, if you find this video helpful, paki-like, subscribe, kung hindi pa kayo nakakapag-subscribe, and then, kung gusto nyo rin tumulong sa mga kaibigan nyo or friends, kakilala, you can also share this video para naman umabot din sa kanila. Okay?